Hi there, good afternoon, and welcome to our talk and roundtable discussion on retained EU law in the post-Brexit world. I'll just wait a couple of moments for colleagues and others to join us as the attendance numbers are still racking up, and we'll get started very shortly. Perhaps whilst we wait for others to join, I'll just introduce myself. First of all, my name is Andrew Hood. I am a partner specialising in the trade and regulatory work, and I head up the Phil Fisher's Brexit Task Force and our public policy practice here in London. I'm delighted to welcome Eleanor Duse and Indira Rao to this fireside chat, as it's been forecast as. There's no fireside, but hopefully lots of chat. I was taken back thinking ahead to this hour about last summer when I spoke to Eleanor and I said to her, "What are your plans for the summer, Eleanor?" Thinking that they would be probably as limited as mine, trying to get away for a week somewhere warm and perhaps finishing the box set of Breaking Bad. Eleanor said, "Well, I'm going to write a book," and indeed she did, on retained EU law, which is what I think we're here to discuss today. Eleanor, being the modest person that she is, will point out that she co-wrote that work, and of course I'm also delighted to have Indira here. Both of them are the co-authors of Retained EU Law, a Practical Guide, published by the Law Society earlier this year, and I'm really delighted that they can be here with us today to talk about the work and about the issues at hand. I have to say it's one of the most popular EU Brexit-focused webinars we've hosted for quite some time. I think it just shows just how relevant the issues are as we come into our post-Brexit world and our new legal landscape. Just briefly, before I pass over to Eleanor and Indira, brief bios of the two. Eleanor works with us here in Phil Fisher. She advises regulators, governments and business on data protection compliance. And prior to joining Phil Fisher, was a senior government lawyer. She was also the UK's lead lawyer in negotiations on the General Data Protection Regulation. She worked as a senior lawyer at the Department for Exiting the European Union, where she led on the core provisions of the European Union Withdrawal Act 2018 and aspects of the withdrawal agreement and the framework for the future UK-EU relationship. So a real source and fount of knowledge on EU law and on the implications and impact of Brexit. Indira, delighted to have Indira here, as a former colleague of mine when I was in government, and a huge brain on EU law as well. Indira is currently the Counsel for EU and International Law at the House of Commons and has over 20 years of experience advising on EU, public international law, constitutional and administrative law in both Parliament and government, following 5 years of experience at a Magic Circle law firm at the start of her career. Indira has been the lead lawyer at the Foreign and Commonwealth and Development Office, advising on legal issues arising from the UK's withdrawal from the EU. And her previous roles include senior legal advisor on EU and international law at the Attorney General's Office, legal advisor at the UK Permanent Representation of the EU to the EU of the UK, and the UK agent to the European Court of Justice. An enormously long CV, an enormously experienced practitioner. So really delighted to have you here with us, Indira, as well. Very briefly, a couple of bits of housekeeping. It is designed to be a Q&A and hopefully interactive and useful to those of you joining us today. There should be a box on your screen, on your control panel, where you can ask questions. Please do fire away. We'll do our best to incorporate those into our discussion today. And if not, there'll be an opportunity either at the end to ask more questions, and if we can't get through to all of them, we'll do our best to follow up afterwards. But really a huge thank you to both Indira and Eleanor for joining us. A little bit of context before I go into my very first question, which is just a reminder that, of course, the post-Brexit legal landscape is enormously complex. I mean, there's both the withdrawal agreement we need to think about and the Northern Ireland Protocol, which we are constantly in our minds, the Trading Cooperation Agreement as well, of course, between the UK and the EU, and the new domestic framework, legal framework that applies, all of which have bearing on the issue. But the retained EU law element, I think, it's quite enough to be going along with. We're going to have a very full hour, and And if your practice involved any EU law prior to December 2020, or your company was affected by EU law prior to December 2020, then retained EU law is going to be relevant to you. Clearly, it's a complex area. Of course, have reference to the statute, of course, have reference to the exceptions and the schedules to the statutes. And of course, it's a developing area, so we need to keep our eye on the case law. So what I do hope, though, is today we'll have a bit of a roadmap, or at the very least some signposts as to what to look out for as we're going along and navigating some of the issues around retained EU law. So with that very lengthy introduction, let me start with perhaps a bit of an easy question, Eleanor, if I can. Just tell us, why do we have retained EU law? What is it?
Thank you very much, Andy, for that introduction, and good afternoon, everyone. Great to be here. So yes, why do we have retained EU law? Well, on our withdrawal from the EU and also the repeal of the European Communities Act, which was the main piece of legislation that allowed us to implement EU law in our domestic legal system, with those disappearing essentially and us leaving the EU, we'd have had a huge gap in our law if we hadn't done something about it. So EU law would cease to apply to the UK, and also the European Communities Act has an awful lot of legislation that was made under it to implement our EU obligations. So had we done nothing at all of that law would have just fallen away. So a huge range of areas would have been affected. Employment law, health and safety, competition, financial services, data protection, consumer protection, the list goes on. So a fix was required, but there were relatively limited options. The timeframes were very tight, and the government policy was to focus on legal certainty and continuity so that people would know what the law was on the first day after the transition period ended. So what happened was that a snapshot was taken. So the EU Withdrawal Act takes a snapshot at the end of the transition period of all of the EU law that applies to the UK at that moment, and turns it into domestic law. So we're going to unpack what that means in a bit more detail, but that EU law that applies at the moment transition period ends is turned into domestic law, and also the domestic law that implemented EU obligations is also saved to create that continuity so that everyone knows what the law is when the transition period ends. So that's why we have retained EU law, those components of the EU law, the EU obligations which applied, and the domestic law which implemented EU obligations. Those together form retained EU law. So that's why we have it, to create that continuity. So I think Indira is going to take us through now some of those components of retained EU law.
That'll be great, Indira. So just if we stay in this overview mode, it'd be great just to hear a little bit about what those components of retained EU law are, just so we know sort of exactly what we're talking about, and we're all starting from the same page.
Yeah, absolutely, and good afternoon, everyone. So retained EU law is a really complex, intricate concept, and to understand it properly, we really need to break it down into its component parts. Now, we should have a diagram just coming up on the screen. That's about to come into view. Yes, there we go. So this diagram shows us what the component parts of retained EU law are. So I'll just go through and name check them first, and then we'll go through them one by one. So as you can see from the diagram, retained EU law is made, oh, it's gone. It's made of, there we are, it's back. It's made up of EU-derived domestic legislation, direct EU legislation, a third category, which I'll describe for present purposes as a sweeper category of EU rights. And these three components are interpreted in accordance with retained case law and retained general principles. Now, I know that's a lot of terminology to digest, and we'll unpack that, and we'll keep the slide there so you can see, you can orientate yourself. So I'm going to start off by looking at EU-derived legislations, EU-derived domestic legislation. Bit of a mouthful. So this category of retained EU law itself breaks down into a number of elements or strands. It's a bit like those Russian dolls. I'll focus on the elements which practitioners are most likely to come across. So, in essence, EU-derived domestic legislation is domestic legislation which was made before the end of the transition period to implement the UK's EU obligations. The first element of it is secondary legislation made under the European Communities Act 1972. And an example of that would be the UK's working time regulations, which were made to implement the Working Time Directive. Another element would be secondary legislation made using powers under an Act of Parliament other than the European Communities Act. So, for example, the International Tax and Compliance Regulations were made to implement an EU directive using powers in the Finance Act. The next element to mention is Acts of Parliament passed to implement EU obligations. So, for example, the Pollution Prevention and Control Act. And there are some more elements of EU-derived legislation which have what I would call a looser link to the implementation of EU law. So, for example, when the UK was an EU member, it would sometimes not only implement the obligations in a directive, but it would go further than was strictly required. And in the jargon, it would gold plate the directive in domestic law. So where domestic legislation not only implemented EU obligations, but went further, the gold-plated bit also counts as EU-derived domestic legislation. So that's just sort of an overview of what comes within that first category. And I'll hand over to Eleanor to take us through direct EU legislation.
Thanks, Indira. Yes, so direct EU legislation, which you'll see in the centre of the screen there, is the law that applied directly in EU law that applied directly in domestic law without the need for further implementing legislation. And you may recall in the case of Miller, the first Miller case, that the Supreme Court looked at the European Communities Act and how it worked. And it said that Section 2.1 of the European Communities Act provided what it called a conduit pipe, which allowed some of our EU rights and obligations to flow in directly into domestic law. And so an example of an instrument which flowed directly into domestic law are EU regulations. So, for example, the General Data Protection Regulation flowed in through the conduit pipe of Section 2.1, and we didn't have to do anything more in order for that regulation to create rights and obligations in our domestic legal system. So EU regulations and EU decisions, so direct EU legislation, flowed in and is now, through the EU Withdrawal Act, saved, kept in our domestic legal system at the end of the transition period. Another element that is within scope of direct EU legislation is tertiary legislation. So that's a legislation which comes underneath, for example, an EU regulation. So an example of that would be adequacy decisions, which are made under the General Data Protection Regulation. So they allow the free flow of data from the EU to a third country, and they were saved through direct EU legislation. That was the starting point. So those adequacy decisions were saved into domestic law. So that's an example of tertiary legislation that's saved in direct EU legislation. There are some exceptions to be aware of here. So, for example, it was decided that we shouldn't save all of the foreign language versions of those regulations and decisions. So we don't have the GDPR in French and German and that sort of thing applying in domestic legislation. It's just the English language version. Another important exception is that some instruments partly flowed in through Section 2.1 of the European Communities Act and were partly implemented in domestic law. So where they are implemented, those elements fall within the other definition of EU-derived domestic legislation, which Indira's just mentioned. So there's an exception which makes sure that they're not saved twice, once in the regulation, perhaps, and once in the domestic law. It's simply the domestic version which applies. So that's a canter through direct EU legislation, and now Indira's going to look at the Section 4 sweeper provision.
So this third category in our diagram is the one category that's not given a pithy label in the EU Withdrawal Act. So in high-level terms, it's a sweeper category. Essentially, it's made up of EU rights that had direct effect in the UK. So as a reminder, a right had direct effect if it was clear, precise and unconditional, and it could be relied on by individuals in domestic courts without the need for prior domestic implementation. The origin of the rights in this category could be EU treaties or directives, and an example of a right that you would find in this category is the right to equal pay from the Treaty on the Functioning of the European Union. And then looking at our little, the strip along the bottom of the diagram, you'll see reference to retained case law and retained general principles. These are relevant in the context of interpreting retained EU law. And Andy, I think we'll come back and say a bit more about them later.
Yeah, I've got lots of questions of my own, but some questions coming in as well. One of the questions we're getting is, and we often get actually, is there's references to saved regulations and to saved decisions, but not saved directives. So what happens in that context, and in fact to the recitals in those directives, which of course can have some relevance and bearing themselves?
Yes. Yes, this is really an area that has caused some confusion. Why didn't we save directives in the EU Withdrawal Act? Well, directives, if you think back to when the UK was an EU member state, and actually that's a really useful tip, I think, with all of this, is, if it seems confusing, think back to how it was before, and then that often makes more sense in terms of how we've saved the rights and obligations. So directives are an instruction to member states to legislate. And so once you've legislated, you don't still need the instruction to legislate because you've got the national law. And so the EU Withdrawal Act doesn't save directives because we've got that national law on the statute book. But the way in which you use directives, even though we haven't saved them, still applies. So, for example, as you mentioned, Andy, looking at the recitals of the directives to interpret that domestic law, that still applies. That's still an approach which is appropriate. And similarly, the duty of consistent interpretation, so that you might bend the words of the national law a little bit to make them consistent with the directive, that still applies as well. So the old approaches are still valid, but we didn't save the directives, so we didn't duplicate essentially that instruction to legislate and the legislation itself.
Thank you. I think it's always good. What sometimes seems like simple questions we're afraid to ask, so it's always good to kind of air them. And I would say to those listening in, please do feel free to send through your questions for Eleanor and for Indira as well, and we'll try to, as I said, incorporate those as we go through or bring them up at the end. But one other question I have then, Indira, coming back to sort of your point around the reference at the bottom of your diagram, which talks about the interpretation in accordance with retained case law and general principles. I mean, can you just talk a little bit more about what that means? But in reality, what does that actually mean on sort of day-to-day basis?
Yeah, absolutely. So to put it in context, retained EU law has its own set of rules for how it should be interpreted. As ever in this area, there are various exceptions and qualifications, but in broad terms, retained EU law, which has not been modified, should be interpreted in the same way that EU law was interpreted. But there's a bit of complexity here. If the retained EU law has been modified, then it will either be interpreted in the same way as EU law, or the ordinary domestic rules of interpretation will apply. It all depends on the intention behind the modification. And this is a new concept that's been introduced by the EU Withdrawal Act. And we'll have to see how the courts go about ascertaining the intention of a modification. And that's, I think, one area of interest that will develop. But getting back, so what does it mean to interpret retained EU law in the same way as EU law? Well, there's some useful guidance in a recent Court of Appeal case, Lipton against BA City Flyer. And as the Court of Appeal says in that case, when a domestic court is faced with interpreting retained EU law, it may, for example, take a purposive approach to interpretation. It may look at the recitals to EU legislation as an aid to interpretation. And retained EU law is also to be interpreted in accordance with the retained general principles, which we have mention of in our diagram. So the general principles are principles of EU law that have been developed and applied by the Court of Justice. And examples include the principle of proportionality, the principle of equal treatment. So they are used as aids to interpretation. And a domestic court must follow any relevant CJEU case law made before the 31st of December 2020 when interpreting retained EU law. And I think Ellen is going to tell us a bit more about that and explain some of the exceptions.
Yes, thank you, Indira. Yes, so the general position is that if you've got case law dating from before the end of the transition period, so be it EU case law or domestic case law which interprets EU obligations, then those are still binding on the UK courts after the end of the transition period. So those cases still have the same status effectively as they had before the transition period ended. So that's that theme of continuity that we talked about earlier, and an example of that continuity of interpretation and meaning. But Court of Justice decisions that are handed down after the end of the transition period, so from the end of December of last year onwards, are not binding on domestic courts. So they can look at them in the same way as a court might look at an Australian decision or a decision from a New Zealand court or something like that, but they are not binding on domestic courts, those post-transition period Court of Justice cases. Now, that's the starting position. There's a bit of a nuance here which is worth being aware of, which is that certain courts can depart from end of transition period Court of Justice case law. And that's the Supreme Court that can depart, the High Court of Justiciary in Scotland, and the Court of Appeal and equivalent courts. And they can depart on the basis of the test which is used by the Supreme Court when it departs from its own case law, which is when it is right to do so. And there's been some recent case law from the Court of Appeal on this. It looks like courts are going to depart relatively rarely from the pre-end of transition period Court of Justice case law. But there is a possibility for those courts to do that where they consider that it's right to do so. So that's, yes, that's an important aspect, I think, to be aware of, that the status of Court of Justice case law now after the transition period's ended.
Thank you. And just sort of following up on that, I was trying to weave some of those two thoughts together. I mean, you've talked about, you've noted how sort of retained EU law will remain a part of domestic law, and it still retains some features of that. And we've just talked about sort of the notion of case law and how that affects. So what does that look like in reality? And can you give us an example, perhaps through that supremacy discussion? Just elaborate on that a bit further about what that looks like in reality.
Yes. So this is one of the things which I think commentators found very surprising about the EU Withdrawal Act. That you've got this principle of the supremacy of EU law, which still applies. And so I want to sort of just give an example of why that is. Again, it goes back to that theme of continuity. So I think the point was we didn't, you know, that the statute book shouldn't necessarily become unbalanced, and that would be, you know, really undesirable after the transition period ended. So this is all about having the same rights and obligations essentially, you know, the day before as the day after the transition period ends. But let me just illustrate how that works in terms of supremacy. So again, we sort of go back in time to when the UK was an EU member state, because that's a really helpful way of working out how things have changed and developed since the transition period ended. So say, for example, you had an Act of Parliament that dated from 1995 that said that all footwear in the UK must be red. And then in 2005, the EU decided to legislate in this area, and it brought forward an EU regulation that said that all footwear in the EU must be blue. So whilst we were an EU member state, because of the supremacy of EU law, the law would have been that all footwear in the UK would have to be blue because the EU regulation took precedence over the Act of Parliament. So that hierarchy is preserved under retained EU law. So the saving of that concept of the supremacy of EU law means that that position doesn't change. So the law still is, if there's no change to the law, that the EU regulation takes precedence over the Act of Parliament, and all footwear still, after the end of transition period, must be blue. But if Parliament decided to legislate in the Queen's speech a couple of days ago to say that the colour of footwear in the UK should be changed, and so the government brought forward a Footwear Act of 2021, which said that all footwear in the UK had to be yellow, then that would take precedence over retained EU law. So it really is about preserving the hierarchy, preserving the way that the statute book interacts until the moment when change is brought about by new domestic legislation. So in this example, this Footwear Act, which takes precedence over retained EU law. So that's an example of how supremacy is still relevant, supremacy of EU law in our domestic legal system.
Brilliant. I shall forever take that example of yellow and blue footwear with me. I think in terms of how I think through these things, it's one of those things that's stick in the mind, even though my footwear is by and large white or black, very unoriginally. And just picking up on that discussion on sort of EU exit regulations, in fact, that's another sort of major area that really is going to affect everything we do and how we interpret and apply the law now in our day-to-day work with, as advisors of the clients and those in-house counsel working with their colleagues. So those UK exit regulations are already sort of a vast swathe of legislation, which there's hundreds of them. And let's be honest, there is some varying quality of those regulations. I'm sure absolutely nothing to do with either Indira or you, Eleanor. But what's the best way, and sort of just what's the best way to go around thinking about how to understand and to apply those in the sort of our day-to-day work? I don't know, Indira, do you want to answer that?
Yes, very happy to come in on that. Yes, I think this is an issue that a lot of practitioners will be grappling with. So I think it's helpful to go back and think about why these EU exit regulations were needed in the first place. So if we think back, the EU Withdrawal Act transplants law that was made for one environment into a different environment. And the law is not necessarily going to work in the new environment without some adaptations. So the EU Withdrawal Act contains a broad power that allows ministers to make regulations, commonly known as EU exit regulations, to correct deficiencies in retained EU law so it can work in the new context. So let's take an example. Let's say, for example, there was an EU regulation which said that a member state must send an annual report to the Commission on the level of pollution in its rivers. So that regulation will almost literally have been copied and pasted into domestic law. It's retained EU law. It's the direct EU legislation that Eleanor talked us through. But it doesn't make sense in the new context. So the powers in the EU withdrawal agreement could be used to make it work. So, for example, it could be amended, the retained EU law could be amended by EU exit regulations to say a local authority must send an annual report to the Secretary of State on the level of pollution in its rivers. So you're just making it work in the UK framework. Some of the changes are a lot more complicated than that, particularly in the area of financial services. So, for example, the Treasury has made around 50 EU exit regulations to correct deficiencies in the financial services area. But overall, over 600 sets of EU exit regulations have been made, a huge volume, as you said, Andy, and they were made at speed necessarily. Some pieces of of retained EU law have actually been amended more than once. So when you're trying to advise, you may find you've got your retained EU law, and you may have 1, 2, even 3 sets of EU exit regulations. So what's really important is that you make sure you have the most up-to-date changes when you're advising.
I was going to say there was more than twice sometimes as I was grappling in the sort of down in the rabbit warren of one of those yesterday afternoon for a client. So it's a painful process. I mean, Eleanor, do you have an example? I mean, you're a data protection expert, so is there something from, I don't know, from that space where we can kind of hear how that might work in practice?
Yes. I mean, one example that springs to mind is quite similar to Indira's example, actually, that the free flow of data obviously is really important. It allows us to strengthen ties with trading partners in third countries, which is a sort of big policy push now after the end of the transition period. And adequacy decisions, so the EU, I mentioned those earlier, looks at the laws of a third country and decides whether those laws give essentially equivalent protection to personal data as the EU does. And the Commission has conferred a number of adequacy decisions on third countries, Argentina, Uruguay, for example. But obviously, if we simply sort of lift and shift that process into domestic law, it isn't going to work because the Commission no longer makes decisions which relate to the UK. So what do you do there? And this is where the EU exit regulations have come in and made changes to allow that really important function to work in our domestic legislation. So now the Secretary of State has come in, so the EU exit regulations have made that change. The Secretary of State essentially takes over that function that the European Commission had, and the Secretary of State decides, looking at the same criteria as the European Commission, but decides for the UK whether or not a third country meets that standard of protection, so that we can allow them to be deemed adequate and for data to flow freely from the UK to that jurisdiction. So that's an example of where the EU exit regulations have made a change to enable retained EU law to function properly and to allow our important policies to be delivered in this post-transition period era.
Great, thank you. There's a few specific questions coming in, which I'll try and flag up. One of them was around why, so asked why are Rome 1 and 2, for instance, not retained, but other regulations are? What was the decisive factor? So that's one question I'll leave. And another question we've had in was, what's happened to the Charter of Fundamental Rights? So we're darting around a little bit now, but actually just be good to get your take on either of those questions. Perhaps Eleanor, start with, I know the Charter of Fundamental Rights is something you've looked at in the past, so what's happened to that in the context of retained EU law?
Yes, so the policy decision was taken not to retain the Charter of Fundamental Rights, and the argument goes that the Charter of Fundamental Rights simply is a list, essentially, of rights which already exist in EU law. So if you save EU law and turn it into retained EU law, you don't necessarily need that list that sets out what rights are in the law because they're there. So on one argument, the loss or the failure to retain the Charter of Fundamental Rights, or the decision not to retain it, makes no difference. But there are plenty of commentators on the other side of the spectrum who say, actually, the Charter of Fundamental Rights did make some difference and did have its own significance and was capable of being relied upon. And now that that's gone, there is a change to our domestic legal system. And I think data protection is a really interesting example of that, because when people look at the Charter of Fundamental Rights, Article 8 of the Charter of Fundamental Rights, which is right to the protection of personal data, there is, of course, a link to the European Convention on Human Rights, Article 8 of the European Convention on Human Rights, the right to a private and family life. And so there is a sense that in many ways that there may be little difference between the two. And so if you've got the Human Rights Act and the European Convention on Human Rights has been implemented, then you've still got that principle that you can rely on. But there is case law, domestic case law, the case of Watson, where our domestic courts have said, actually, Article 8 of the Charter of Fundamental Rights goes further and has no real equivalent in the European Convention on Human Rights. And therefore, one might argue that the loss of the Charter does actually make a difference. So it'll be really interesting to see what the courts make of this.
Another watch this space, which I guess we'll also can wait for the second edition of the book, which is always advantageous for the authors. And Indira, I mean, perhaps picking up on that Rome 1 and 2 question, why that wasn't retained, whereas other regulations were, and what was the sort of decision-making process behind that? But also perhaps more broadly, a slightly separate question, but in the same sort of category, I think, which is, was it strictly necessary to save EU-derived domestic legislation? I mean, what was the rationale for some of these things about what to save and not to save, I suppose, more broadly?
Yeah, so I don't know the detail of why the Rome 1, Rome 2 regulation in particular wasn't saved, but maybe I could say something about sort of the general process. So as we've discussed, retained EU law is a huge body of law, and there would have been in government a process of going through and checking whether it works in the new context and deciding if it doesn't work, how do you go about making it work? So in some cases, as we've discussed, it might be tweaking commission to Secretary of State. In other areas, it might require more complex changes. And yet other areas, it might require actually getting rid of the retained EU law and replacing it with a whole new regime. And one thing I think we shouldn't lose sight of, that retained EU law wasn't ever actually intended to be a final destination. It's more like a staging post. It was introduced to avoid a gap in the statute book that Eleanor told us about, and it's there to provide legal continuity until Parliament can decide whether it wants to amend it or replace it, or however it wants to change it. So that's how I would answer the first question. Your second question was about EU-derived domestic legislation, and was it strictly necessary to save it? That's a really good question, because in some senses I think the answer is yes, and in some senses the answer is no. And the reason I say that is
very loyally answer yes and no.
Exactly. As Eleanor explained at the beginning, a lot of legislation to implement EU obligations was implemented using powers from the European Communities Act. So if that legislation hadn't been saved by the EU Withdrawal Agreement Act, if it hadn't been expressly saved, it would have all fallen away when the European Communities Act was repealed. So in that sense, yes, it did need to be saved. But as we've discussed, legislation made under European Communities Act is not the only component of EU-derived domestic legislation. So, for example, an Act of Parliament which implemented EU obligations would be EU-derived domestic legislation, and that would have carried on as an Act of Parliament regardless of what the EU Withdrawal Act the EU Withdrawal Act said. So in that sense, it wasn't needed. It wasn't needed. But I think we also need to bear in mind that actually making something retained EU law does have certain consequences. So as we've discussed, retained EU law is interpreted in a certain way, and the power to make EU exit regulations can be used in relation to retained EU law. So I hope that sort of explains how the system operates.
Yeah, no, really, really helpful. And one of the questions we've had in just kind of highlights, again, coming back to this point about the breadth of EU exit regulations, of their mapping across, of the nature of retained EU law and the complexity of it all. One of the questions we've had, which I shall try to put as neutrally as possible, and recognizing that neither of you are in government, but we'll have your own sort of sensitivities as to what you can answer, particularly Indira. the question says there are still lots of gaps as we've shifted across. For example, and they give the example of the MHRA have not yet replaced a whole scheme which was required to authorise approved online medicine sellers. Don't think we're expecting you to talk about the MRHA and online medicine sellers, but do you know if the government accepts that there's still some catching up to be done in this area or and across lots of different areas potentially? Are there still gaps to be filled, basically? Eleanor,
well,
why don't you, let's leave Indira in sort of splendid silence.
The power to amend retained EU law under Section 8 of the EU Withdrawal Act actually lasts for 2 years after the transition period ends, and there are good reasons for that, which is that this was an absolutely enormous exercise. Huge amount of work has gone into all of this, and as I said at the beginning, really short time frame to think through how these changes needed to be made. And it's inevitable, I think, that there will have been gaps, that there will be things, as we said, many areas have several EU exit regulations which are relevant to them. I think just because of the complexity, because of the scale of the task, because of the policy decisions that have had to be made at speed, and perhaps with a little bit more time, people have thought about the fact that actually what about this and what about that, and they've had to readjust things. And so I think it was very deliberate and it was anticipated. That's why we have these powers still in force, that changes need to be made. And it doesn't surprise me if someone says that there are gaps, because this was the most enormous change at pace that we've seen. I mean, usually when you legislate, you're legislating in a particular area for a particular policy. But to legislate like this right across the statute book is really unprecedented. And so those powers, I think, are still needed probably and will continue to be used until they are sunsetted.
Thank you. Various questions outside of the realm of retained EU law specifically, and so, but I think it's probably helpful, Eleanor, perhaps it's on GDPR, so if you don't mind, we'll take advantage of your presence here. There are a few questions on GDPR, we may not get to all of them, but just to give a flavour of the wider context, I suppose, in which this sits. One of the questions has asked, how does a withdrawal agreement and the GDPR, how do they work together? How do they interact? I think just having a flavour of how those agreements and the legislation and what have you fit together might be quite useful as a reminder of how this framework all fits together.
And I think the first thing to say is that it is very opaque. It's very complex. So you've got the layer of retained EU law that we've focused on now, but then you do need to, in your particular area, look at whether the withdrawal agreement has an effect, and that will generally take precedence over whatever's happened in the context of retained EU law. And then the trade and cooperation agreement above that may also have had an effect. And then you've got new domestic frameworks as well, which may affect what the answer is to a particular legal question. So having gone from a position where I think we all felt quite confident about the law that we advised on, we now have a whole new legal system which is really untested to work through. So in terms of data protection, I mean, that's a good example. We've got complexity with EU exit regulations that we need to work through to understand the significance of those. And of course, the EU Withdrawal Act itself has very little case law that attaches to it. So I think there will be things that we discover about how we interpret the UK GDPR, as it's now called. So the GDPR has turned into domestic law. On top of that, we've got the withdrawal agreement, and before our EU adequacy is finally signed off, which hopefully is going to happen very soon, there are some provisions in the Withdrawal Act which say that legacy data that's come from the EU during our EU membership or during the transition period has to be protected in accordance with the GDPR as frozen on the last day of the transition period, but you also have to take into account the case law of the Court of Justice as it develops to protect that data. So in a way, you've got two different regimes operating at the same time. That all disappears once we get an EU adequacy decision, but that's a bit of complexity, which is as a result of the withdrawal agreement. So retained EU law, unfortunately, isn't the end of the story. So hopefully that we don't need to worry about that, and that'll all go away soon when we get our adequacy decision. But on top of that, you've got the trade and cooperation agreement, which itself contains quite a few provisions about data sharing, very detailed ones in the context of law enforcement data sharing, which may be relevant to you. So there's that layer as well. And then potentially we're going to have quite soon new UK standard contractual clauses, and there'll be a question, Indira talks about, how do you interpret those? There'll be a question as to how those are interpreted. Does the old retained case law apply to those or not? So this is a new framework. So what's the intention of the modification here? So that's just a very short canter through one area where there is tremendous complexity really to work through. So I think we are all feeling our way here, and the legal system has become really, really opaque.
Opaque is never a word you want to hear from lawyers or people who know the area super well. In fact, the issue of standard contractual clauses is another question that's come in, but we'll perhaps go back directly on that rather than take everyone down the rabbit hole of data protection issues. One final question for either of you, which is just, we have a lot of in-house counsel on the line who are sort of trying to deal with this day in, day out and understand how they can provide the best way through and figure out the best way through and provide practical solutions to their clients. So what's your advice to them working through the best way to work through what is clearly a complex legal framework? Indira, Eleanor.
Shall I kick off, and then maybe Eleanor, you might want to add to it. I mean, I think one thing is that, and this is really unprecedented. It's unprecedented change to our statute book. So if you are finding it difficult and you are grappling with it, I would say, well, it is complex, and I think a lot of people are just pleased to hear that is a general feeling. It is actually very difficult. It's a developing area. There's case law coming out. We've had two very interesting decisions from the Court of Appeal recently. So I think it's an area where you really need to pay attention to the statute. It's a complex statute. There are lots of qualifications and exceptions. It's all very highly interconnected. There's a lot of detail in the schedule to grapple with. So you really need to give yourself the time and space to think it all through. And I think it's one of those areas, because it's all so new, you haven't really got anything to, you haven't got a whole body of law and practice to refer back to. So I would say sort of stick with it, give yourself the time and really pay attention to the statute itself and what it says.
Eleanor?
Yes.
Any top tips?
I think the two top tips actually, because we're working, because the EU Withdrawal Act works across such a huge range of the statute book, you're not going to find the perfect answer potentially. But look at the signposts. There are signposts throughout the legislation which sort of, when taken together, do point you in a particular direction. So have a look for those. We've set those out in our book to try and help you to navigate this really complex territory. And I think thinking about it in that way does help. It's not all going to be nailed down, because it couldn't be, because it just is operating across such a broad spectrum. And there will be, potentially competing arguments, and you'll have to make strategic decisions about what way you want to go on that, and just get comfortable with the fact that there's not necessarily going to be an easy answer. I mean, some of the questions we've grappled with over the last few weeks have really been quite fiendish. So don't be dispirited to sort of slightly echo what Indira said if the answer isn't obvious, because it probably isn't obvious, and you just need to sort of take a step back and think about it and think, what would we like to achieve, and do we have the sufficiently respectable arguments to take us there? And then I think something I've mentioned before, but really probably does bear repeating, which is that, thinking back to what would the answer have been when the UK was an EU member state, what was the approach have been when the UK was an EU member state, can be really helpful actually. It's those sort of core principles of EU law that actually it's quite useful to remind yourself of, because we all operate so sort of automatically within them. But actually, now we've got the EU Withdrawal Act, now things have changed, going back to those and just refreshing our memories on those and thinking, okay, yes, that is how a directive worked, or that is how a regulation worked, and therefore the answer must be this. That really helps, I think, to go back sort of in the time machine and think back to our EU membership and how the law worked then. And I think that often does unlock the sort of right answer or helpful answer in a particular context.
Super helpful. I wanted to make that my last question because I thought actually, and you both resisted more or less, I think, saying the best practical tip is to go and buy this book, £65 from the Law Society. There is, I think, actually a 10% discount to anyone who's tuned in. So we'll send the details of that round so you can save your organisation a whole £6.50. I mean, who doesn't want to save a penny these days? But on a very serious note, and I get absolutely no commission for this, it is a really accessible book. It's drafted in a way that really, I think, picks up your points around the signposting, around helping people to navigate what is a really broad and frankly very complex area, and one that's going to change. I think it, for me, helps give you the skill set to start to work through those issues. Of course, I will just pick up the phone to you, Eleanor, and ask you what the question and what the answer might be. Not everyone will have quite the same luxury, but genuinely a really useful tool to start to think about how we frame and understand some of these issues, how it sits alongside the wider complex legal framework we've alluded to and talked about a little bit today. But it is complex, which is an easy thing, I think, honestly, for lawyers to say, especially in private practice, because we think, well, everyone's going to come rushing to us for advice. But actually what we want to do is make sure that people have practical tools at their disposal in order to sort of address some of the questions that will come through to them, and frankly are quite fiendish, to pick out that word. So without labouring the point, that I think that the retained EU law, your summer was well spent, both of you, looking at this, pulling down those threads, the core arguments and the threads and the building blocks to help people to work through it for themselves going forward. And I think, yeah, hats off to you. Thank you very much for doing it, and thank you for coming today. I was really honoured to be asked to host this discussion is a grand word for a slightly stilted conversation in these environments, but really huge thank you for your participation today and for sort of taking us through what we described at the beginning as a bit of a roadmap with the signposts that are there. I think it's been really helpful. So I don't want to drag this out for too long, but just, yeah, huge thanks from us and from those participating, and for those who were able to dial in and weren't able to get to your questions, we'll do our best to send you to respond to those questions. We'll send around the 10% discount code, and if you've got any further questions, then by all means drop me, Andrew Hood at Phil Fisher, or Eleanor Deuce a line, and we'll do our best to respond to those or find someone who can. We'll spare you that luxury in Dira, but thank you very much to both of you for today. Much appreciated, and yeah, good luck with the retained EU law to everyone out there. Thank you.
Thank you.
Thank you.